Thank you both so much. Mr. Secretary, thank you so much for coming. We appreciate it. You get your proud CalMatters member sticker.
All right.
Thank you very much.
Great stuff.
Thanks, sir. A little hearkening back to the way things maybe used to work a little better than they do now, right? We're going to talk about now with our Attorney General, and to interview him is Nigel Duara, who is a justice reporter for CalMatters. Long history of reporting. Once everybody know he came out of the Missouri School of Journalism, and has been at both newspaper and broadcast jobs around the nation, and has been with us for several years doing some amazing work. So I'm going to invite Nigel and the Attorney General to join us.
Please have a seat. Yeah. Rob Bonta is a former state legislator who served 5 terms in the Assembly. In 2021, he was appointed Attorney General by Governor Newsom. As California's chief law enforcement officer, he's focused on housing rights, regulating tech companies, and countering a surge in fentanyl trafficking. He is the first Filipino American to serve as Attorney General of California. Please welcome Rob Bonta. Thanks so much for making the time. So we've only got 20 minutes, so we're going to get right to it. Okay, thank you.
Quiet.
Yeah. So after the killing of George Floyd and the protests that ensued across California, legislators, including yourself, offered a raft of bills aimed at changing police practices. That included bills that opened the disciplinary records of officers, that forced departments to disclose their military-style weapons, and ban the use of chokeholds. It's been nearly 4 years. Has any of that legislation made a difference yet?
Yeah. Well, first, good afternoon. Rob Bonta, California Attorney General. Thank you to CalMatters for pulling us all together. Thank you for being here. I'm honored to spend the next 20 minutes with all of you. And thank you, Nigel, for the question and the conversation I know we're going to have. I think they all made a difference. Just one in the sense that in a moment of pain, and there was a rising up to turn pain into purpose and purpose into change. And we were all committed to addressing a systemic inequities and to deliver durable solutions. And the legislation that you just mentioned are some of those. There was more. There was additional legislation as well. And then, of course, there's the time it takes to implement and to measure the results. But I think they were all important, you know, from SB 2 and decertification, having California bringing up the rear in this space and policy area where other states had already had decertification policies, where law enforcement officers who were engaged in sustained serious misconduct could no longer have the right and privilege to continue that very important profession. If they failed to meet the standards, that's important. We have that now. Same with military equipment, same with positional asphyxiation and other changes. I think they've all made a difference. They were all part of a commitment to both a safe and a fair future, and making sure that we're using best practices and changing as we learn that there's broken parts of the system and try to fix those parts.
Sure. And you knew this one was coming. One of the bills was AB 1506. That's what you authored with Kevin McCarty when you were in the legislature. That bill put the Justice Department in charge of investigations into police shootings of unarmed people. Sorry to repeat, that's AB 1506. Then, after it passed, you had this pretty unique opportunity to put it into practice as Attorney General. So far, you've closed 10 of those cases, and that's still right. None of them has resulted in criminal charges against an officer. So, kind of a two-part question. What do you say to families and Californians who've been frustrated that unarmed people are getting shot and the police aren't facing criminal charges? And what has DOJ learned from the cases that it has closed?
Well, AB 1506, a bill I authored, an interesting connection for me, since I authored it as a legislator and then I'm in charge of implementing it as the Attorney General, required that the Attorney General's office, not a local district attorney's office, conduct investigations and make prosecutorial decisions about officer-involved shootings that lead to the death of an unarmed Californian. So by definition, these are very difficult cases. These are unarmed civilians who've been shot and killed, and they require investigation. The whole purpose, and I can say this as a former author of the bill, as one of the co-authors of the bill, was to make sure that there was independent review by a separate entity, a different entity than the district attorney's office that works with those officers every day. And that whatever the outcome of the investigation, there was often a lack of trust in the system when the local district attorney's office was the one conducting the investigation. So by the very nature of the bill being passed and being implemented, and us, the DOJ, a separate entity who doesn't have a day-to-day relationship with the law enforcement officers that we are investigating, there is more trust, there is more independence, there is more objectivity in the investigation. So that is a success, just the very fact of the implementation. Another key component of AB 1506 was to require that recommendations be made to law enforcement departments about changes, permanent changes potentially in practices, in approaches, in their systems that they could embrace going forward to avoid some of the challenges and problems that had occurred that led to or contributed to the incident, even if there's no criminal charges. That is positive. That is a benefit. So the law is working as it should, with an independent review and decision-making, with recommendations on practices and policies that can change going forward, and we need to go faster. We have closed 10 cases. We need to close more quickly. We are always in a tension or a sort of co-prioritization of speed and accuracy. You can't be fast but inaccurate. It is not good to get the decision done right away and have it be inaccurate, incomplete, or unfair. And you shouldn't take forever to get to an accurate decision. We're starting to speed up even faster than we have in the past. We've made changes to our approaches. We've changed leaders in certain roles. We've changed our systems so we have faster throughput. In the last 3 months, we closed 5 cases. So we are at an unprecedented level of efficiency. We hope to maintain that and even improve on it going forward. And to folks that are wanting answers, I hear you. I want answers faster too. And we are going to continue to commit to faster, accurate answers for the public, for the families of those who've tragically lost someone, and for everyone who's interested in our independent judgment and assessment.
Can you tell me a little bit more about the change in leadership? What did that entail? Was that Department of Law Enforcement, or was that the lawyer side?
We have 3 parts in our system. We have the law enforcement that conducts the investigation, literally can get a call any time of the day or night, roll out and mobilize and go to a scene where there has been an officer-involved shooting that led to a death of a Californian. We have, after the investigation is complete and wrapped, a prosecutorial criminal division that looks at the case, makes a decision about whether we should prosecute this case and prove to a unanimous jury beyond a reasonable doubt that the law enforcement officer involved committed a crime. And then we have our civil rights or police practices attorneys who look at the practices, the policies, the systems. So there's 3 different entities. We made a change at the criminal prosecutorial space. We also made some changes at the civil rights police practices area so that there's more resources that can prioritize these cases more quickly. And we think that has led to us speeding up as well. And good old-fashioned lighting a fire under folks coming from me, I think, has helped as well.
I'm going to have to do a story about that. So for a few years now, there's been a concerted effort by police chiefs and sheriffs to overturn Prop 47. And for folks here, that's the 2014 law that changed certain low-level crimes from felonies to misdemeanors. They, the police chiefs and sheriffs, have been arguing since the law's inception that Prop 47 is leading to more crime because there's less threat of punishment. That movement is reaching critical mass this year with the ballot measure. So tell me, from your bully pulpit there, how are you going to protect Prop 47?
Prop 47 was passed by the people. Any decisions to change it will be made by the people. So if it qualifies, it gets on the ballot, it withstands any litigation, you will decide. The people of California will decide. I have always believed that a threshold in Prop 47 that creates the distinction between a misdemeanor and a felony at $950 is what the data shows that it is, one of the strictest thresholds in the nation. 40 states have higher thresholds, meaning they don't become a felony until you steal more than $950. So California has one of the strictest thresholds at $950. The state of Texas, it is a misdemeanor when you steal $950. It's a misdemeanor when you steal $1,000. It's a misdemeanor when you steal $1,500. When you steal $2,000. When you steal $2,499. It doesn't become a felony in the state of Texas until $2,500. So California is strict from an evidence-based perspective when it comes to the threshold. And a misdemeanor is a crime. A misdemeanor is a crime. A misdemeanor is a crime. You can go to prison or to jail for up to 6 months. You can pay a penalty. There's no such thing as being able to steal under $950, and it's not a crime. It's a crime. It's a crime. And so we will need, I would need to see, personally, if I was gonna, when I go into the voting booth, to see some data as to why that threshold is somehow leading to the things that some people claim. I like data. I like evidence. I like not just claims, but claims supported by data and evidence. I think the legislature has been wise and thoughtful in some of its decisions. It's taking on issues like aggregation, when you steal in multiple places at multiple times as part of a common plan. If it's part of a common plan, you can aggregate the amount stolen, and it can lift you over the $950 threshold to get to a felony if it adds up to more than $950. They've dealt with repeat offenders. They dealt with an issue where before a law enforcement officer could not arrest you if the crime wasn't in your presence, even if there is video evidence and surveillance evidence of you committing the crime. Really? So that's an important change. Also some restraining orders or stay-away orders that have been implemented. So I think the legislature has responded to many of the concerns with a set of legislation that is responsive, thoughtful, and effective. It doesn't actually change Prop 47, but again, Prop 47, votes of the people, can only be changed by votes of the people. I do title and summary, and I don't get involved officially in propositions I do title and summary on until they are in what's called the free and clear area. After they've qualified, they're on the ballot, and there's no possible litigation. So that doesn't happen to the very end.
This is a tough spot for you, I think, because police chiefs and sheriffs are, some of your biggest constituents. The way you do your job is that. If they're telling you this, but they're not backing up with data, what do you tell them? Without disclosing names and stuff, what do you tell them in conversations where they're saying, look, this is the reason for crime, and we got to do something about this, where you see the data and it doesn't appear that to be the case?
I point to the data. And different perspectives are not just fine, they're encouraged. We get to better places when we have different perspectives, different views. People bring different opinions, life experiences, data, evidence, statistics to a conversation. I have my perspectives. I also am willing to change them and have them evolve if presented with different facts, different evidence. So the conversations that I have with our sheriffs, with our police chiefs are very important. And our DAs, I will continue to have them. I will always be open to evidence, interested in arguments and if different perspectives that will help me make the best decisions I can. But I lead with evidence and data, and will continue to ask for it in support of a position. And if it's compelling and persuasive and present, that might change my mind.
Understood. Anyone that receives the press releases from your office knows how many lawsuits you all file, how many you join, and especially during the Trump administration, boy, oh boy, they were flying. National polls show that Trump has actually a good chance of winning in November. California filed more than 100 lawsuits, 110 I think, against the Trump administration. Those range from energy efficiency standards to immigration enforcement. What are you doing now to prepare for the possibility of another Trump administration?
We focus on the here and now for sure, and what we did yesterday, what we do today, what we will do tomorrow will always be guided by our firm and immovable commitment to our values, to Californians' future, to our people, our natural resources. And we had been in a time for 4 years where there was a Trump administration, the Department of Justice fought like heck in support of our people in our state. Over 100 lawsuits brought against the Trump administration for violating the law, the supermajority of those successful. Also defending against attacks like the attack to get rid of the Affordable Care Act. Our office, my Solicitor General, argued that case, defended high quality affordable education for millions of health care for millions of Americans. And whatever comes, we will continue to lead, be aggressive, lead with our values, and fight for the people and for our natural resources. So, as an example, the Dobbs decision dropped, and we committed with everything we had to defending, protecting, expanding reproductive freedom, access to abortion, to health care. The same when it comes to Bruin. We are defending with everything we have our common sense gun laws in court as they are challenged. And so you can expect us, no matter what happens, who's the president, or what the challenges are, what the threats and attacks are, we will always fight for the people of California and our values.
Let's talk about one of those that you just brought up. Are you confident that California's protections for abortion are going to stand up in a scenario where Republicans not only get the White House, but also Congress?
I think the willingness and potential for cruelty from some on the right and in the Republican Party to strip away and attack reproductive freedom has no bounds. And Dobbs' decision was portrayed by some as, no, it's just left up to the states, it's fine. Every state can decide. Meanwhile, some in the Republican Party were talking about a national abortion ban. Former President Trump has talked about a national abortion ban and then tried to back away from it and walk away from it. There's a saying in politics, when someone shows you who he is, believe them. So we must be prepared for a national ban. And if... Wow. Well, for one, when the first time after Dobbs dropped, when there was indication from some in the party, the Republican Party, that they wanted a national ban, I asked my team to start writing the brief that we would write to strike down a national ban should it be passed, to think about the arguments, the constitutional anchorings, the legal underpinnings, and all of the approaches. And so preparation is a huge part of success, and being prepared and doing the thinking now, having something ready that you hope you will never have to take off the shelf. But if you need to, you can reach for it and use that tool to protect the people here in California and throughout this country is important. So that is an example of an exercise we've gone through to prepare for one potential future.
Because we don't live in a silo, right? I mean, before Dobbs, I believe Planned Parenthood was getting 30,000 people coming across from out of California to receive abortion care services. Now, obviously, I assume that number's gone up. When you see what Idaho has done, and you're joining a lawsuit, I believe you're in litigation. Yeah, okay.
Yeah.
Yes, you sure are. With that, what does that also look like from state to state? I mean, how does that wash up on California, even if California maintains all its abortion protection rights?
We're very proud of California's leadership role. I think we've been a source of hope, a source of light, of inspiration, a blueprint for what is possible for those who wish to make sure that rights and freedoms are protected for their people. And we don't just want it to be true for Californians. We want all Americans to enjoy similar rights and freedoms. And so we've become a safe haven, a place where folks who seek an abortion can get it safe and legally here. And we have state funding and nonprofit, non-governmental funding to support folks when they travel here and when they need accommodations if they can't afford it, to seek that health care here. So when the Arizona Supreme Court made a decision giving life to a law that essentially banned abortion in almost every circumstance, and that was the new law, I talked to their Attorney General, Chris Mays. And she said, how can we work with California to make sure that patients can, who want an abortion can come right across the Arizona-California border and receive care, or how our doctors who can no longer provide abortion care can do that right in California. We talked about it, we planned for it, and we prepared for it. We will continue to do that, and we will continue to be a beacon of hope and a safe haven.
If I were to ask everyone in this room, I think that they'd want me to finish with this question. Mr. Bonta, are you running for governor?
Is that true of everyone in this room?
I mean, I'll take a poll later.
Really?
I'll go ask everyone.
I think it might just be you.
It's only me.
I'll say this. I am honored for the question. I've been asked the question before. It's something that I will make a decision on at some point. That time is not now. The time now is to be the best Attorney General I can be. It is a consequential job and an impactful job. People's lives and people's health and people's future rely on what we do and how well I do it. So I'm committed to doing the best I can. I think that the best audition for anything that might come next is to do as well as you can where you are. So I'm focused on where I am. I never thought I could be the Attorney General of the state of California. I will confess to you that sometimes I secretly go on the website to see if my name and photo are still there. And I get pumped when I see both, because that means I can do more to help the people of California. So I'm focused on being the best Attorney General I can.
And that's our time. Thank you, AG Bonta.
Thank you, Nigel. Thank you, CalMatters.